This is the Financial Intelligence Podcast brought to you by the UK Financial Intelligence Unit. The UKFIU has a national remit to analyse information on economic crime received through suspicious activity reports. All views expressed by panellists on the podcast are their own and not necessarily those of the UKFIU.
Hi, my name is Emma. I work at the National Economic Crime Centre in the Fraud Threat Team. We are part of the National Crime Agency, and today I'm joined by some colleagues to talk about virtual squatting and the public-private cell work that they undertook. James?
Hello there. My name is James. I also work in the National Economic Crime Centre Fraud Team. I'm here as I was one of the co-chairs for the virtual squatting cell, along with my colleague.
Hi, and I'm Michelle. I'm head of AML at ICAEW, and I have operational responsibility for AML supervision of our 9,500 accountancy firms, and I was James's co-chair.
Hi, I'm Matt. I'm head of intelligence for Companies House, and we played a part in this cell.
Thank you. So maybe we could start with explaining to our listeners what virtual squatting is.
First thing that the cell did was come up with a definition of what virtual squatting meant that the whole cell could get behind. The term is used to describe where fraudsters and other economic crime suspects attempt to create legitimacy to their activities or indeed invade investigation by registering their place of business at service offices, accountants and law firms, but in fact they have no agreement or contract to do this. So they're not there, but they're squatting there, hence the term virtual squatting. Why they do that? Various reasons. Virtual squatting is a key typology for fraud, mostly investment fraud or investment fraud linked products, such as mortgage and financial product fraud, and even government support fraud being enabled by criminals registering bogusly this way.
I think it's also important to remember that there's potentially two sets of victims of virtual squatting. You first of all got those whose addresses are being used without consent, but secondly, those who are the victims of fraud where virtual squatting is a typology. And I'm sure we'll come into all those types of fraud as we carry on the conversation.
Thank you. So having covered what is virtual squatting, what does the threat picture look like for virtual squatting?
And I think Michelle just touched on it back there. I mean, it's used as an enabler in very many frauds. Investment fraud is the one that springs to mind, but then there are other sort of insurance-y frauds, pension frauds, all sort of spinning off from investment frauds, really. To be fair, when we first started looking at this, it was something that both the Virtual Office Forum and local police forces had seen that there was, should we say, a bit of a gap in our knowledge around this. There was a lot of chat saying this is going on. Is there something we could do about it? And this is one of the reasons why we did try to set up the cell.
Yeah, that's right. I think within the accountancy sector, what we'd heard from our supervised population was some anecdotal examples of where they'd seen their office address being used in this way, or, suspicious businesses being registered at their office address. And they'd alerted us to that. So we were really trying to get under the skin of how often is this happening, and what does it look like for the accountancy sector in particular when we were thinking through what the cell wanted to do.
Yeah, I mean, the accountancy sector were beaten with a big stick by people thinking, well, this accountancy firm's been, and it was nothing to do with them. It was just somebody virtually squatting at that office. And it was, like I said, the double victim standard.
You've covered slightly around like the types of fraud and where it came from. And obviously there was a need to look at this into a bit more detail. But what was the scale of harm? At that time, what would you say the scale of harm was?
That was one of the unknowns, if I'm honest. There was certainly a knowledge gap and an intel gap about it. I think we know that there was a lot of fraud, and particularly fraud against the individual. There is a lack of wanting to report. Now we have Action Fraud, which is the UK's law enforcement portal into reporting fraud. We know that it was underreported, and we think it was underreported by as much as about 50%. So I haven't got the figures about how much the report was going on, but like most types of frauds, underreporting was prevalent. We need to get people reporting this somehow, and it's just trying to let people know the avenues that were there.
That brings us on to then what the work you did around trying to really understand the scale and the harm of this. A public-private partnership cell was set up. So what work did that cell do?
So the setup of the cell was to actually try to find disruption opportunities against virtual squatters. It was under the auspices of JMLIT and the Joint Money Laundering Intelligence Team, which are part of the NECC. They commissioned it and piloted it. And a cell was set up with myself and Michelle as joint chairs. They do this regularly, private and public sector joint working. It's a good way to get ideas across that otherwise you wouldn't have, and have a bit of cross-fertilisation about information and things to do. So, yeah, the idea was two things. Look for disruption opportunities and try and embed countering virtual squatting almost as much as a business as usual activity at the end of it.
Yeah, and we had really strong and positive engagement. I think there were 19 cell members in the end, from a broad range of sectors, and as James has mentioned, both public and private partners as well. So, Companies House, across law enforcement, the accountancy sector, trust and company formation. And what that allowed us to do was to bring a real wealth of knowledge and expertise into the room, so we could start to flesh out firstly some of the vulnerabilities, but also to try to identify actual examples of virtual squatting and understand kind of what it looked like in the day-to-day. But that strong engagement then sort of allowed us to pull on different strengths from the group. So public sector members, went down the avenue of analysing bulk data available to them, and the private sectors were able to give really good case studies and explanations about how they were encountering virtual squatting in their day-to-day activities, when they were taking on clients, or their own experiences of their own firm of when they'd come across it. So the cell worked really well, I think, in that respect.
And it was kind of done at the time it was done on purpose, because we were aware that Companies House were getting some new powers to help combat this and other factors, basically getting a lot more new powers and getting a bit more room. And we decided that this would be a good time to actually see what we knew about this and try and bring Companies House on board and see how that could help out. Again, it was one of the things, not only was it under reporting of action fraud, but a certain amount of not contacting Companies House, so they were able to deal with the issue. So we tried to strike while the iron was hot on that to try and get the biggest bang for our buck on that.
It was a really good opportunity for us. As James has said, we had our new powers. We were looking at how we could use them more effectively. We're building our capability in that area. So we're members of this cell. We're members of a number of other cells. And it's very much a statement of intent for us to show where we're heading as an organisation as we sort of change our role from that passive registry into that sort of more active gatekeeper position. In the cell, with the ability to sort of work with partners, we identified 77 instances of virtual squatting. Using our powers, we were able to dissolve 22 of those. We were able to then move 20 of those to the default address at Companies House, which then, if they don't provide us with an effective address, we will then move through to dissolution. And there are a further 10 in that cohort that are no longer using the addresses provided. So it really demonstrates the ability for us to play that active role, to share that information, work across that public and private partnership to disrupt. And we had a really good effect in terms of disrupting some of the sort of actors in this space.
One of the reasons that the cell was set up, or two of the reasons the cell was set up, but one's for disruption purposes. And in law enforcement, we are kind of judged on our disruption activities. There is a thing called the 4 Ps: pursue, prepare, prevent, and protect. And by and large, most law enforcement activities have to have a pursue element to it, which in layman's terms is basically running after a criminal and perhaps kicking down a door and arresting them. Or the other Ps that I mentioned, more often known as the 3 Ps. So most activity would expect to have some sort of pursue and some sort of other 3P activity to this. We were looking at this right at the start off, and we were managed to get a pursue activity with the data that Matt read out earlier about how we were able to stop these actors being able to carry out their fraud. And we managed to get a prepare piece of disruption going on by the publishing of the Amber Alert to the community to enable them to prepare themselves and enable them to know what to do should they identify red flags or identify people or businesses that may be virtual squatting at their properties.
I think one of the interesting dynamics about the public-private partnership was that you were really interested in disruptions, and James would all the time, what about the disruptions? And I was actually just really keen for the Amber Alert. I want to get some guidance out to our firms to help them to understand all the stuff that we'd been talking about for the several months that we had the cell operating for. So we did write an Amber Alert towards the end, where we got all of the information that we'd collected over those few months down on paper and use that to disseminate across to all the regulated sectors, and actually disseminate it far and wide across the full range of regulated sectors. And the alert itself included, so all the way to the beginning, from the definition of what virtual squatting was, talking through red flags, starting to touch on some of Companies House's powers, because I think when we wrote the alert, when it was published in June 2024, some of those powers were only really just coming into play. But we went through all of that sort of information, and with the aim of giving them the tools of how to protect themselves, but also reporting routes and what to do if they did identify virtual squatting themselves.
So my understanding, as a result of the cell, an alert was produced. So how would people access this?
The alert was disseminated through the normal JMLIT channels, and so were shared with all of the regulated firms in the regulated sectors. So if a firm wanted access to that alert, they should go to their supervisory body in order to access it.
So I think we just covered quite a bit of ground there on what the cell did. Are you able to provide maybe one or two of the case studies that you looked at in the cell to give an overview of the kind of threat that you were looking at?
So the main case study was that a professional service firm, which actually does allow clients to use its address as their registered office when the firm has correctly onboarded them with all the full KYC checks and have all the right things like an appropriate engagement letter in place. But they explained to us that they'd seen not only an increase in virtual squatting, but squatters had also become a bit more targeted as well. So not only did they get companies moving their registered office to the firm's address without its knowledge or consent, but they'd found that squatters are looking at actual clients' names and then setting up companies with a name which looks very similar to that. So I don't know, AB Partners Limited is just spelt with a double A in the word partners, for example. And that's probably one of the key things that you see when you talk about investment fraud typologies and things. They do clever things with the names of the company to try and make it look like they're a business that they're not. So the firm itself had developed a system where it had pulled registered office information from Companies House and then was doing, comparisons between that and the data of its own list of approved clients on a regular basis to identify those circumstances where firms were registered at their address and they shouldn't be.
Thank you. Matt, if I could just come to you, you touched on about the new powers and your ability to start exercising those during the course of the sale. Could you maybe just give a bit more of an overview of what Companies House did?
Yeah, so I'll touch on the powers a bit more detail to start with. James has referenced them earlier. So I think it's fair to say they're a suite of wide-ranging reforms, and they say that moves us very much into that space of tackling economic crime, improving the transparency of the register, and you're looking at those corporate entities that seek to misuse the register for criminal purposes. We absolutely are able to go much further than we have before. We have the ability to check information, challenge information, and reject information. And I think I mentioned it earlier. It's very much about that move for us becoming that more active gatekeeper in tackling economic crime. Our focus over the last 12 months has been very much on removing false information. Again, that's in support of individuals, businesses, and others who rely on our data. And a bit later on, I can probably touch on some of the scale of the work that we're doing in this space as well.
Thank you. So what advice would you give to companies going forward around virtual squatting?
On specific advice for companies to protect themselves, I think Michelle's mentioned it earlier. It's relatively straightforward. We make our data available in a wide variety of formats. And in particular, I'd recommend looking at the advanced search functionality that we have. So you can put your postcode in there, you can put your property number, and you can use that to identify your own registered office address. And then if you focus on those ones that you don't recognize, so those that aren't, if you're a trust and corporate service provider, or if you're an accountant we mentioned earlier, so it's not a name change or it's not a subsidiary of an existing company, a client of yours, then you need to take action in terms of trying to sort of get that information off. Now, as I mentioned, we have the new powers to do that. You can refer that to Companies House. That can be done by email, and on the Amber Alert, it does sort of list all the information that we would require. You can also use the RPO7 process, which can be found on the Company House part of the gov.uk website, and refer that into Companies House. So if that address is being misused inappropriately, or then we can remove it. And just to give an idea of the scale, in the first 12 months, we've removed somewhere in the region of 83,000 suspicious or inappropriate registered office addresses. So that's in the period from the 4th of March when the powers came in until the beginning of March this year. So it just shows the scale of the activity we're taking. And if you report that information to us, then we will take action against those who are misusing your address.
So, Matt, could you explain what an RPO7 is?
Apologies, I've used the RPO7 term here, which not everyone might be familiar with. So RPO7 is actually a form that we have where you can apply to the registrar to change addresses. But it probably is worth pointing out as well that you don't actually need to do an RPO7 form. You can just email Companies House with the relevant information. However, I would recommend that the RPO7 form is used because that gives a framework of the information we require to remove that information. And the more information we can get upfront in the relevant detail will allow us to act more quickly and more promptly without having to go back and forth to require additional information.
Thank you.
It won't surprise you to learn that coming from a law enforcement perspective as well, it's one of those things that we want people and need, not just want, we need people to report this, because there are things out there like action fraud reports as well. There are your regulators. You have the FCA that you could go to. There are, if you think there's money laundering involved, you can SAR. We're only as good as what we're being told, and we need to be told because otherwise we can't act.
Yeah, and so we've kind of covered there the ways in which businesses or firms can protect themselves, but in the wider picture, I guess to James's point about protecting the public, the AML regulated sector, has its obligation to do the work that it needs to do to check AML risk and all the good stuff that comes with customer due diligence. And to be able to do that effectively and to make sure that you understand, really understand who your clients are and all the risks and red flags that go with them, you need to understand what the risk and red flags are in the first place. So things like the type of thing that firms should be looking out for when they're taking on clients for the first time, the use of the Companies House default postcode and address could be a potential red flag. And maybe Matt can talk a bit about what that means actually in real terms for those that don't understand it. But there's also other things such as if a company has changed its registered office many times, that might be because Companies House has forced it to, or somebody else has, effectively kicked them out of their virtual squatting situation and they've gone to the next address and to the next address. There's other more subtle things such as the registered office or the principal place of business are not at the same location. That doesn't have to be a red flag. It's, sometimes that's justified and there's good, valid reasons why that might be the case. But as always with red flags, it's quite often the build-up of those circumstances and the build-up of those red flags that leads you into that higher risk or the suspicion area. So once you kind of get that combination of red flags, the money laundering regulations themselves dictate that you need to be thinking about enhanced due diligence. And that fundamentally in this scenario means you need to understand more about the business that you're taking on to make sure that it's legitimate and that you understand why its addresses are the way that they are, or that its place of business is the place that they've told you that it is. And so again, you can check the registered address of the business for Companies House databases, as we've already talked about. And as James said, start going off to other sources of information. So the FCA has warning lists of unauthorized firms. The Solicitors Regulation Authority has different scam alerts for other types of business that look to be illegitimate businesses in themselves. And you kind of piece all of that information together to bring together your enhanced due diligence picture. So you've done all your EDD and considered through all those red flags and risks, and you'll probably come to one of two conclusions. Either everything stacks up and it's all okay and makes sense in the context of this particular client, or it doesn't stack up and you're left with residual concerns or suspicion. And at that point, that's when you'd want to consider submitting a suspicious activity report through the NCA SARS portal to make them aware of that suspicion.
So I'll just pick up on the point that Michelle made about the default addresses. So when companies report that their address has been misused, depending on the weight of evidence that we get from the complainant, we can either remove that information straight away and put it to the company's house default address, or we can write out to the company and give them 14 days to demonstrate that they're entitled to use that address and give evidence to show that that is the case. If they don't, as I say, we remove that to the default address. So effectively what that means is the registered office for that company will show as the company's house address. And going back to the point you made earlier, Michelle, that in itself wouldn't be the only indicator of a red flag, but actually once you look at that in terms of the filing history in conjunction with the other red flags that you've mentioned, it does sort of suggest that there may be something that warrants further attention within that company.
Well, I'd like to thank all of my colleagues who have come here today to talk about virtual squatting. It was really interesting, and I'd like to thank all of the listeners for joining us. To keep up to date with the latest UKFIU podcast, magazines and other guidance products, please visit the NCA website. Find the UKFIU on X, formerly Twitter, and also LinkedIn. You'll also find the full collection of UKFIU podcasts on Spotify and other major streaming platforms. Thank you for listening. I've been Emma, and this has been the UKFIU podcast.